finish the week strong with some major news with the Supreme Court we're waiting on. We're just moments away. I'm Bill Malugin. Millions of Americans are waiting to find out what the court has to say on this, about President Biden's plan to wipe away $400 billion in student loan debt. Two related cases are challenging the president's authority to forgive the loans, and there are several possible outcomes besides just an up or down ruling.
A lot of questions still out there, and we're answering them right now as we await today's opinions. Shannon Bream is standing by outside the court. Hi, Shannon.
Okay, so this is it, Dana and Bill. I mean, we are down to the wire. We know these student loan cases are coming today. We know this case on the Colorado web designer, the free speech religious liberty issue, is coming today as well. The question on that student loan case continues to be, does it get punted on an issue of standing? They spent so much of the time of the arguments talking about whether these parties, the group of states, these red states that brought the case, and these borrowers who brought a separate case that, they then joined together at the court, do they, either one of them, have the right legal posture to be the ones to have this case heard? There was a lot of doubt, and it wasn't just among the left-leaning justices on the court during the arguments. So do they even get to the merits of the case? I feel like because they've held it to this last day, my gut says they should have gotten to the merits because they've taken a long time. We would expect that they do. So we'll see. We'll know within moments. And the first case it looks like that we have is the Colorado web designer. Now, this is the web designer who said she's an artist. She doesn't want to do custom web designs for anything that disagrees with her personal religious beliefs. I can tell you that it's written by Justice Gorsuch, and the court is apparently holding that the First Amendment bars Colorado from forcing this website designer to create expressive designs speaking messages with which the designer disagrees. Justice Sotomayor is dissenting. Kagan and Jackson, those two justices, joining her as well. So it looks like, I don't have the hard copy in my hand just yet, but it looks like this is going to be a 6-3 decision in favor of the web designer here. You remember the case with the baker out of Colorado a few years really didn't settle these issues. This came as a free speech issue, and it looks like what the court has decided is that she can't be forced to speak messages that she doesn't want to in her designs. And so this is that, that intersection of religious liberty, free speech, along with the anti-discrimination protections for the LGBTQ plus community. She has said she'll serve anyone, and she has had LGBTQ plus customers. She just doesn't want to do custom artistic designs that would do something against her religious beliefs, in this case, same-sex marriage. And I think we maybe have them coming. Sarah, thank you very much. And let me just check the rundown on this. Yes, authored by Justice Gorsuch. He's joined by the Chief Justice Roberts, Thomas, Alito, Kavanaugh, and Barrett. Justice Sotomayor files the dissenting opinion, and Kagan and Jackson join her. So the first one that we were waiting on, let me flip through here, as Justice Gorsuch, who has written other cases that have to deal with religious liberty issues, and this is a free speech issue. Here's what he says at the end of his decision. He says, "Tolerance, not coercion, is our nation's answer. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Because Colorado seeks to deny that promise, the judgment is reversed." So 6-3 in favor of that web designer, as we now wait to see, will they read some from the bench, as we heard yesterday, which would delay us getting those student loan decisions, but they're up next, guys.
All right, Shannon Bream, thank you so much for that quick work, as always. I know this is one of your favorite days of the year.
It is.
For more on this, Jonathan Turley is the constitutional law attorney and Fox News contributor. As Shannon just said, that a lot of people remember the cake designer case. And I think a lot of people would remember, oh, that got settled in favor of the guy. But as she said, it actually didn't answer all of the questions. So now that we have this ruling from the Supreme Court at 6-3, does this answer the questions? Does this give us finality on what the decision is at the Supreme Court?
It does. This is a momentous victory for free speech. I've been following this case since it was in front of the 10th Circuit. And the 10th Circuit gave a full-throated endorsement of the right of this Colorado Commission to force this website designer not only to take these contracts, but also to take down statements on her own website about her religious beliefs. Justice Gorsuch has said that that is all unconstitutional. I cannot express how important this case is for the First Amendment. For years, many of us have argued that the court was approaching these cases wrongly. In the Masterpiece Cake Shop case that you referred to, the court took an exit ramp and actually threw him back to this commission. And that guy languished there for years. trying to defend his religious rights. Many of us have argued that these cases should not be religion clause cases, but free speech cases. And what happened here is that the court could have considered both issues, but refused the religion clause claim and said that they were only going to look at free speech. And this is why. Because Gorsuch is saying that we've always been clear, you can't coerce people to say things. And what is being done here is telling a website designer, you have to say things through your website designs that you believe are wrong. And Gorsuch is saying that's not allowed under the First Amendment.
Jonathan, go ahead and stand by for us. We want to send it back out to Shannon Bream at the Supreme Court. I understand, Shannon, you've got the dissenting opinion here. Go ahead.
Yeah, I want to read a little bit from Justice Sotomayor. Justices Kagan and Jackson joined her in this. She says, today is a sad day in American constitutional law and in the lives of LGBT people. The Supreme Court of the United States declares that a particular kind of business, though open to the public, has a constitutional right to refuse to serve members of a protected class. The court does so for the first time in its history. Again, the plaintiffs in this case wanted to distinguish that. She has served customers of all different backgrounds, faith, no faith, all different sexualities and genders. And she says, you know, essentially, I'm happy to serve anybody. I've worked with all kinds of clients. I don't want to do custom messages for custom events or certain things that are in conflict with my religious convictions. So clearly, Justice Sotomayor sees this differently than the majority did. The majority says this is about compelling free speech to be something the government wants it to be and not what somebody personally believes. This business owner has said she will serve all people. Justice Sotomayor has a real fear that this decision will be used to say something totally different. So a pretty clear 6-3 split. It appears that there is some reading from the bench going on right now because we don't have the student loan case, which we'll get any second.
All right, Shannon, thank you so much on that one. And we await the student loan decision as well. We'll let you continue to read through that. Get back to Jonathan Turley here. What about somebody watching this who would say, but that doesn't make sense because no matter what sort of gender or you claim you are or what your sexuality is, if you go into a grocery store and you want to buy something, you just go ahead and you buy it, and of course they have to serve you. And if you could just explain the distinction of the free speech issue about the custom part of this cake or the website design, excuse me.
Right, that's a critical distinction in that these cases, Masterpiece Cake Shop as well as 303 Creative, do not change the public accommodation laws. You cannot be refused to go into stores and buy items that are pre-made, for example, based on your race or your status. In fact, in Masterpiece Cake Shop, the owner said, no, we don't discriminate against anyone. We don't make any inquiries. It's only when you ask me to make a cake that expresses the celebration of a same-sex marriage that it really confronts the religious views that I have, and I don't want to do that. So what the court is saying here is that with these types of creative products, it is speech. And for those of us in the free speech community, this is an amazing moment. This will go down as one of the most important free speech cases in the history of the court. It'll go down as one of the most important cases Gorsuch has ever handed down, in my view. It is a huge victory because it brings clarity to an area that was muddled and confused. The court is making a very strong statement in favor of free speech. I'm mystified by the dissent. You know, when Sotomayor came up for confirmation, I noted that she had a troubling free speech case as an appellate judge. But that hasn't been as pronounced until today. I mean, her dissent really gives very little weight to the free speech concerns raised by many of us about these issues. In my view, the reason it's a free speech case is because I would feel the same way about Nazis going into a bakery and asking a Jewish baker to produce an anti-Semitic cake, or to ask an African-American baker to produce a KKK cake. Various people have strong feelings that they don't want to be forced to express countervailing values. It doesn't mean they're right or they're wrong, but we have the ability to accommodate that. And what Gorsuch says, and it's a really beautifully written opinion, is he says we can accommodate that in this country, that we believe in pluralism, we believe in letting people have their own values. And so the distinction you drew is the most important of all. you must comply with public accommodation laws. This is a limitation of when you ask someone to do an expressive act in the form of a cake, a website, maybe a photographer.
So this is another 6-3 decision with the conservative majority. Yesterday, President Biden was very critical of the court and its decision. Here's some of what he had to say.
I strongly disagree with the court's decision. This is not a normal court. What I meant by that is it's done more to unravel basic rights and basic decisions than any court in recent history. Take a look at overruling Roe v. Wade. Take a look at what the decision today. Take a look at how it's ruled on a number of issues that have been precedent for 50, 60 years sometimes. And that's what I meant by not normal.
So, Jonathan, you hear him. He says it's not a normal court. He's criticizing the court, but he wasn't criticizing it when they've recently sided with him in several decisions.
Yeah, this court has handed down major victories for his administration. It has not been rigidly divided. Most of the court cases are still unanimous, nearly unanimous, and the ones that aren't have a mix that don't break along ideological lines. It's really these few cases, these cases like 303 Creative, where you see that strong division. But that's because of these deep-seated jurisprudential views. I wrote a column about the president's comments last night because I thought they were very troubling. First of all, he cites he calls it the Constitution, but he cites to the Declaration of Independence and saying that somehow yesterday's decision counteracted the promise that we would treat everyone equally. That's a rather curious take, because what the court thought it was doing was precisely that. The court said you need to look at people as individuals. You can't just check off boxes. And just as we don't allow racial discrimination in employment, we're not going to allow it in higher education. Now, you could disagree with that, but to say, as the president did, that this reverses the ground gained in the Civil War is just really beyond the pale in my view.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.